Representative Greenman, we have House File 3093. Since you're not a member of the committee, I will move the bill up for consideration. You have a DE4. I will move the DE4 to be before the committee. Would you please discuss the DE4?
Thank you, Madam Chair, and it's nice to be back in State Gov. This House File 3093, the DE, it reflects the work of that I've been doing with admin, with MMB, a bit with Department of Labor and others over the last 9 months since I originally introduced the bill, and puts the bill in the shape I'd like it.
All right. Thank you, and I understand you wanted a roll call. Is that correct? I understand. I will call a roll call. Roll call requested. Roll call will be granted. Okay. Sorry, we're moving on. All right, please go forward.
Do we need to adopt the DE?
We do. Oh. Yes. So I'm requesting a roll call on the DE4. Will you please take the roll? You know what? The bill will be the DE4 at the end of the day. We'll take the roll call at the end. I will suspend the roll call until we act. Members, all in favor of adoption of the DE to get the bill in the author's preferred state, please say aye. Aye. Any opposed? Okay, that was much faster. All right. Thank you. Representative Greenman, to your bill as amended.
Thank you, Madam Chair. As I said, the DE and this bill adds a minimum eligibility criteria to the pre-risk assessment for grants in 16B. This bill implements a simple concept that entities that steal from the state government shouldn't be eligible for government grants. The policy is modeled after the responsible contractor requirements in 16C that mandate compliance with unemployment insurance laws, workers' compensation laws, tax and labor requirements for contractors and subcontractors of public projects that exceed $50,000. This bill bars any organization from receiving state grants if that entity or its subsidiary or related entities have been found to have violated Minnesota's misclassification law and related violations that skim money from public coffers. I learned about this gap in our pre-risk assessment framework while chairing the misclassification task force. In the 2024 OLA report on misclassification found that in addition to the impacts on workers and other companies, misclassification affects the state and federal government finances through, and I quote, lower program and tax revenues, increased reliance on government services. In 2025, Northstar Policy Institute estimated that misclassification fraud cost the state government between $506 million and $1.3 billion, which includes unrealized state income taxes, payments in the unemployment trust fund, and workers' compensation premiums. And last year, in a bipartisan vote, we passed a bill that will allow us to actually get a state report about how much that's costing the state in the future. And while we have advanced policies at other committees to enforce and deter misclassification, it's also critical that when an organization breaks these laws and rips off the state, that they're barred from getting state dollars from other grant programs. That is something we've talked a lot about in the Fraud Prevention Committee, ensuring that we have policies and the vetting in place that prevent people getting caught from defrauding one public program from continuing to get money from another. This bill closes that gap in 16B by adding these minimal eligibility criteria to the current framework. It identifies and disbars potential grantees in violation of Minnesota law. It requires certification of compliance that a potential grantee is in good legal standing and paying their taxes, is paying and in compliance with Minnesota state programs, workers' comp, UI, paid leave, does not have repeated state or federal labor violations, prevailing wage violations, wage theft violations over the 3-year period, does not have an organizational leadership that has been criminally convicted of failure to pay state government, state funds, medical assistance fraud, and other fraud crimes, and has not already been barred from state, federal, or any state agency in the state. This minimum criteria applies to potential grantees and their related entities, which we added that language on technical assistance from Department of Admin, who wanted to make sure that some of their experience was that people, if you had an issue, if you had a violation, you may construct yourself in a different way in order to continue getting grants, and we want to avoid that circumvention to prevent bad actors from getting around legal restrictions. Misclassification fraud is fraud, and it cheats workers, and it also, and I think importantly to this bill, steals from public programs, and the bill protects those public programs and ensures that when we've done our enforcement action, we don't let those folks continue to get resources and grants. This is a common sense part of our shared work to stop fraud and stop our public programs from being abused, and to ensure that fraudsters who cheat our taxpayers are cut off from other sources of funding. And with that, Madam Chair, I do not have any testifiers. I have admin and DLI are here in case people have questions.
Okay, I did have that Betsy Hayes wanted to testify. Is that incorrect?
Oh, that's, sure. Yeah,
No,
that's great.
okay,
Oh,
that's
for questions.
just available for questions. Thank you so much. Members, do you have any questions? Oh, Representative Sexton.
Thank you, Chair. Chair Creeman, thank you for bringing this bill forward. If one word would describe the DE4, I would say comprehensive, so thank you for that. This bill, combined with our strong OIG bill that we've recently passed out of committee, really, to me, bookends both deterring and prosecuting fraud, so thank you for that. I do have a couple of questions. I'll refer you to DE4, page 5, line 5.26. It's minor, but I think it puts us in a bit of a conflict of interest situation. So where we start with.
Wait.
Excuse me, could you make the reference one more time, please?
Sure, 5.26. The very first word is agency.
Madam Chair, can I just clarify? You're talking about the underlying statute?
No, the DE4.
Sorry, but
The DE4, line 526, where it starts with the word agency.
I see that. I'm just clarifying. This bill does not make any change to that. So you're talking about the underlying statute in law?
Yeah.
Okay.
Right. But I'm asking for clarification, and possibly we would have the opportunity to make the bill stronger if we made a change.
Did you prepare an amendment?
I did not, since I just read that last
Okay.
night with the DE4.
I would encourage you, the bill is going to,
Ways. But
please go ahead.
Madam Chair,
Representative Freeman.
I am happy to, I've been talking to Representative Schultz and a few others who are in the Fraud Prevention Committee. I'd be happy to work on any of this language to make it stronger, especially if we share the value. I am less familiar with the part of the statute that I am not changing in this bill, so, but look forward to that. And it is going to Ways, and would love the conversation.
Absolutely.
Representative Sexton.
Thank you. So I'm asking, and obviously you don't have to give an immediate answer as you consider this, but the part where it says agency must either create a plan to satisfy the remaining concerns with a grantee or must not award the grant. I think that puts us in a situation where we're coaching and really we should be evaluating. I think that's the basis of your bill. So I would recommend scratching, starting with must either create a plan to satisfy the remaining concerns with the grantee, and somehow just clean up the language so we just stay in the evaluation of the grant and not get ourselves into a coaching, because I don't think we could even capture that in a fiscal note. We have plenty of consultants that they can hire to refer to help them out.
Thank you very much, Representative Sexton, and you've noted that. Right, that would be a conversation for a future time. Any other questions? Representative Koznick.
Thank you. Kind of more of a statement, but last week we had a bill, and I don't have the bill number. Representative Anderson had a bill to not renew licenses to those that had, in current statute, there's a whole list of statutes that if you are found guilty of breaking those statutes, she suggested adding a few others that you do not renew a license if you're guilty of a couple additional things with, trying to remember, it was Medicare fraud or welfare, and then frauding, transactional fraud. I would encourage you to take a look at that, and as you go to Ways and Means, something that could be incorporated into this bill. It did not pass out of this committee, unfortunately, but I think the spirit and the intent are very similar, and so I would hope that you would consider that, or maybe we'll talk about it offline and with Representative Anderson and see if that's something that you would be agreeable to as well.
Thank you. Representative Lugar-Nicolai.
Thanks, Madam Chair, and thank you, Representative Greenman, for this bill, which I think is excellent and is another continued effort in reducing misclassification and hopefully eliminating it in our state. I think it's important to keep in mind that misclassification, when it involves underpaying folks after the point of having secured the contract, is of course a crime against both the state and the workers. When it involves underbidding, it's also a crime against other bidders in the case of competitive grants or other types of procurement. And so I think this is really critical legislation, and I'm so glad that you're bringing it.
Thank you. Any other questions? Okay, seeing none. The motion is to re-refer the bill as amended to Ways and Means. All those in favor, please say aye. Aye. Any opposed? Hearing none, the motion prevails, and you are on your way as amended.